Good morning, everyone, and thank you for joining us. Welcome to the Legal Fight, Get Ready for COVID-Related Legal and Regulatory Claims webinar, brought to us by Ryan Swanson in Cleveland, who is a WACA Associate Business Partner. At Ryan Swanson, they value the relationships they have built and believe those relationships are the cornerstone of everything they do. Whether it's business information, litigation, estate planning, or any legal issue you may encounter, personal or professional, Ryan Swanson in Cleveland are here to help you succeed. There's a few housekeeping notes here for you. The webinar will be recorded today. If you have any questions, please type them in the Q&A box at the bottom and we will address them at the end of the webinar. You're experiencing technical difficulties, like you can't hear very well or can't see the presenters, let us know by also using that chat box. CEU instructions and how to obtain your certification for today's webinar will be sent out no later than 4 o'clock tomorrow, December 11th. Presenting for us this morning are Ryan Swanson in Cleveland's Kristen Meyer and Madison Burke. Good morning and welcome, ladies. Thank you for being here.
Thank you so much, Diane. We really appreciate the opportunity to be here. And first, before we get started, I just want to thank all of you who are on the line. We appreciate your work and understand just how challenging things have been for you. So from the bottom of our hearts, thank you so much for all of your work. My name is Kristen Meyer. I'm a partner at Ryan Swanson in Cleveland. I have been representing long-term care facilities in regulatory issues, some transactional, mostly liability related claims since I started my career almost 20 years ago, and I have come to really appreciate all of the hard work and challenges that are faced by long-term care facilities. And so we're hoping to help you with a little bit of what you can expect and some tools for you to be able to prepare now for anything that may happen down the line. And with me is my colleague, Madison Burke, and I will let her introduce herself.
Thanks, Kristen. Good morning, everyone. I am a fifth-year associate at Ryan Swanson in Cleveland, practicing in our healthcare group under the mentorship of Kristen Meyer. So I have really enjoyed getting into this practice area and working on these claims and representing skilled nursing facilities and adult ALFs, and I'm excited to be here today to talk about COVID. We've been doing a lot of work, as I'm sure everyone can expect. It's been a busy time all around. So we're excited to be able to talk about that with you today. So I don't know if we just want to jump right in.
Yeah. So there's some things we're going to talk about today, and this is sort of an outline about what we're going to talk about. And in order to provide some context to how COVID-related potential lawsuits will be presented or pled, we're going to talk a little bit about what a standard lawsuit looks like. Hopefully, none of you have had that lovely experience of being a defendant in a lawsuit. And so we want to at least provide sort of the basics. If you have been involved in a lawsuit, some of this is going to be familiar to you, but we want to sort of give a basic idea of what that looks like. And following that, we are going to tell you some of the things you already know about how COVID has impacted your world, but we're going to do it from a documentation, legal, and regulatory framework in terms of what our plaintiffs' counsel and surveyors going to be looking for when they view what you have done in response to COVID through their individual lenses. And so then we'll specifically talk about lawsuits, what we've already seen, what you may be able to expect, both from a patient care perspective, also an employee perspective. And then finally, we want to give you some tools as to what you can do now to be prepared in the unfortunate event that you have a claim from an employee, a former employee, or a patient or former patient. We're going to leave some time for questions, as Diane said. So please, as you go along, provide some questions, and then we can go back and talk about anything that you would like more information about or clarification about.
All right.
Madison's going to start with,
yeah,
go ahead, Madison.
All right, so as Kristen said, we're just starting with a kind of primer introduction on the standard lawsuit. If there is such a thing, every lawsuit is different, and factually we have to analyze them each based on their specific circumstances. But in general, what we see in standard lawsuits is that the resident has just a handful of arguments, and all of them break down ultimately to the argument that the standard of care was breached by the facility. So some of the ways that they support this argument and the typical evidence that we'll see in these suits is survey results, statements of deficiency, or admissions by the staff that they did something wrong or didn't follow the standard of care or the policies that the facility itself has put in place. And then also expert testimony that talks about applicable regulations and laws that regulate the facility and govern the standard of care for the facility and how those regulations and standards weren't followed. So we can go, to the next slide. So typically in these cases then, we have these arguments from the plaintiff's side, and the way that facilities are able to best defend themselves is with their record keeping. So you really only have two different types of evidence on the defense side. You have your records, and then you have testimony from the individuals who were involved. A lot of times these cases are very removed in time. So you have up to 3 years from the incident that's part of the claim to file the lawsuit. And then the civil case itself can drag on for quite a bit of time. So before you would ever get in front of a judge or jury, it could be 4 or more years from the incident actually occurring. So you could obviously see that testimony can have some downfalls in that case. Even the best nurse or best, assistant or manager isn't necessarily going to remember on December 10th, 2018, what services did you provide to Mr. Smith or Mrs. Smith? The memory occasionally fails us in those regards. And so in that way, we really rely on excellent record keeping. So putting everything in the chart as it's being done. Some examples besides the chart are the policies. So again, any of the facilities policies will be able to present as evidence of this is our standard of care and this is our typical practice. Then of course the charting, and the best thing for charting is to actually fill it out. So if you have anything included, you can see in our second bullet point there, if this is including your IO charts, or for example, if you're prescribed to have the aide turning the patient every 2 hours and there's a chart to actually mark that that's being done, if it's going to be included in the chart, you need to make sure it's being filled out. It's better to not have that in the chart than to have it half filled out or not filled out at all, because the assumption is always going to be that if it's not filled out, it wasn't done. So it's really important that we're capturing all the factual information of what was done, what services were provided, what medication was administered, that will be able to show that record, which was recorded at that moment in time, versus someone trying to have a recollection years later of what was actually done. And then of course, a successful IDR. These are all great evidence for you to be able to defend yourself in these lawsuits. So we can go to the next slide. Big part. Oh yeah, go ahead.
Go ahead, Madison.
Oh, I was just gonna say, I'm turning it over to Kristen. This is her first thing I feel like she taught me as a brand new lawyer, is that the thing they don't teach you in law school is that it's not just about the evidence, it's also about being able to make that evidence into a great story. So the jurors are people, the judge is a person, and you want to be able to present your evidence in a really compelling way. So Kristen will talk more about how that plays into defense.
Thank you, Madison. So this is true, in my view, no matter who you're talking to in presenting a defense against a surveyor, an OSHA investigator, an APS investigator, plaintiff's counsel. Anytime that you're involved in anything legally related or regulatory related, your defense is much more compelling if there is context for what you have done and you have a story. It's not just the words on your page, in your progress notes, in your MARS, in the other assessments that you have done. As you know, those are all very important. That's what surveyors look at. Eventually, that's what the plaintiff's counsel and her experts are going to look at. But if you have a compelling story about why you did what you did, what the residents were doing, what the employees were doing, and what was happening in the facility to provide the context around those medical records, you can go a long way in furthering what you would like to have happen in terms of defending those lawsuits or providing information to those surveyors. So everything that we're going to talk about today, whether it's on the regulatory side or the lawsuit side, is about storytelling, because we are human beings, even surveyors are human beings, and we are all storytellers. We react really well to stories. And so everything that we're going to talk about today is in the context of how you tell your story effectively. So there's a lot of stories in what we've been talking about, sort of a standard or a normal lawsuit. You all have seen these, seen these sets of circumstances. You all are caring for residents who are quite ill or have a lot of comorbidities. And so sometimes the natural health of that person does what it does. You've all seen it. Staff does everything they can to make them comfortable, but you're not going to heal every wound. You're not going to prevent every fall, because these can be quite frail people that you're caring for. People understand that if you tell that story right. Some of your residents have their very own ideas about how to take care of them or what they want to do. They want to get up, even if they're not supposed to. They want to eat candy and milkshakes, even if they're diabetic. So they have the right to do that, and they should. And again, people understand that. So if those sorts of narratives are presented, it's a much more compelling story. And again, accidents happen. Sometimes things just happen because we're all human beings. That doesn't necessarily mean that anybody at the facility didn't meet the standard of care. So I don't need to really tell you how COVID has impacted your caregiving, and I'm not about to try to do that, but I do want to kind of educate you maybe a little bit of what that looks like from different kinds of lenses that you are going to potentially see. Maybe you have already seen from surveys and also from various other regulators, as well as potential lawsuits. So I thought this was really interesting. I saw a presentation from a consultant to litigation that did a number of surveys monthly over the last, I think, 4 or 5 months during COVID, asking a number of different questions about different people's thoughts about long-term care, about lawsuits, kind of their perception of what's going on in COVID and how it impacts you as long-term care providers. So there's a number of slides over the course of this presentation that we're going to present. These results were from about a week or 2 ago. And so obviously these statistics will have changed over time and probably will continue to change over time as the impact of COVID changes, as the really challenging parts kind of recede in our memories. But this is a snapshot of people's opinions right now. And as you can see, 43% of people surveyed believe that long-term care facilities have a very favorable attitude toward long-term care facilities. And 35% have a moderately favorable attitude. So that's 78% 13 with no opinion. So all of the headlines that you see, the negative press, that isn't necessarily reflective of the population at large. And so I want to at least encourage you that the general population does believe that people at long-term facilities, the operators and owners, are working really hard to address all of the challenges that COVID is presenting. So that was the good news. The bad news, or the more challenging news, as all of you know quite well, is the sheer volume of paperwork or electronic paperwork that all of you have received over the last 8 months, in the hundreds. And the problem, as you all know very well, is that these directives and guidance documents are coming from a number of different places: CMS, DSHS, CDC, OSHA, and they touch on every possible aspect of your business and how to care for your residents. And so just keeping track of them is challenging enough in the midst of trying to address the actual medical and clinical issues that COVID presents. And the issue from our perspective, and what we really want to emphasize today, is that you as providers are going to be held accountable for what you knew. First of all of those pieces of paper and emails you received from the various agencies. And then what did you do? Did you comply with them? What response did you provide in an attempt to address the COVID threat? And so we're going to drill down a little bit more today, both from the regulatory perspective and the legal perspective, of what surveyors and plaintiffs' counsel are going to use to basically figure out if you complied with all of these regulations and guidances that have come down the pipeline. Madison's going to talk about just even one example that we have seen and heard about.
Yeah, so the example that we highlight here is about the N95 mask fit testing. So it's an annual requirement that there be performed and documented that it was performed, this fit testing, for all of the employees who are required to wear this PPE. As you guys are all, I'm sure, aware, and the population in general, I think, at this moment remembers, there was a period of time where the masks themselves, so the supply of the PPE, was not readily available. So if your facility was running out and not able to find because of the increased demand due to COVID, then how do you comply with these annual requirements that you're performing the fit testing, let alone the requirement that your employees are wearing this equipment when they're performing their tasks? On top of that, there was a unavailability of the actual performance of the fit tests. So you had, on the one hand, the government regulation and guidance telling the facilities that they needed to be wearing this equipment and they needed to be performing and documenting these tests. And then on the other hand, the reality was that the equipment wasn't available and the supervision of the test wasn't available. And so when you're in these types of situations, how do you protect yourself, protect the facility? And I guess we can go to the next slide, but at the end of the day, and we'll, maybe bore you by repeating this over and over, is that you have to document. So if the reality is that there was no N95 masks available, or you had a shortage, then those are the things that you need to make sure that you have documented, so that if a claim comes around and makes an allegation that employees weren't wearing the proper equipment, or an employee brings a claim that they weren't properly protected because the facility didn't provide them with the required equipment, you're able to show the efforts that you went to try to comply, and that the facts of the time made it impossible for you to do so. And I'll turn it back over to Kristen to talk more about.
Yeah, so we did see a slide that show that there's favorable attitudes towards long-term care facilities in general. But what is going to happen from a plaintiff's perspective, and the story that they're going to try to tell is what you've seen in the news that has been discouraging and frustrating for all of you. So there is a narrative out there that the facilities just didn't do enough. It isn't necessarily, there's been some stories that it's an intentional, there's cover-ups, etc., but most of it is just, you know, the facilities just didn't get it done. And that because of the high-risk population in long-term care facilities and the vulnerability of that population, the expectation that you protect the residents from this pandemic and from harm is quite high. So again, when we look at this survey, it's reflected in the responses from those who were surveyed. And the question is, do operators of nursing or assisted care facilities have a greater responsibility to protect their residents and patients than those of other healthcare facilities? And as you can see, a vast majority, 78% of respondents, hold you as operators and management in long-term care facilities to a much higher standard than those in hospitals or clinics or public health entities, because we all know that the residents of your facilities are more vulnerable, and therefore there is a perception of a heightened responsibility that you have. And you may feel that too. The folks that I talk to and meet with who are in the long-term care industry, you're there because you have big hearts. You're there because you care about people. You want to care for people. You're not doing this because you're making millions and millions of dollars. And so you know what the responsibility is, and that's reflected in the general population, which will have an impact if you get to a point where you're sitting in front of a jury, or even with investigators. As I said before, they're human too. So one of the other kind of flip side of issues that long-term care facilities and healthcare facilities in general face before COVID and now during COVID is this idea of profits over people. I'm sure you've all heard of it before, and it is the kind of opposite of what I've just said, which is you're not in it for the money. But Plaintiffs' Counsel does, especially for the facilities that are for profit, that there is this idea that you're going to squeeze every last dollar out of your operations in order to put those into shareholders or owners' pockets, as opposed to taking appropriate care for your residents. That's reflected in some of the news stories that we have seen, and that is just an attitude that all of us have to work really hard to negate. But it's out there, and it's something to keep in mind as we are, again, telling our story about the big hearts of your employees and the care that is provided to this vulnerable population.
So
go ahead, Madsen.
Yeah, so typically what we've seen, which we'll get to a few examples, but what we've anticipated, heard, and seen as cases have started to get filed is that the plaintiffs have a certain approach that they're taking to these cases. The first is evidence of a lack of preparation that predates COVID. So if you've already received, the facilities received citations in the past, if there have been issues with proper staffing, they're going to lay that narrative out to just show that now what they're alleging with regard to a COVID outbreak or a death resulting from contracting COVID is that this is just more of the same, right? This facility has been breaching the standard of care. They continue to do that. We also, just like we talked about in previous slides, all of those hundreds of pages of documents and communications and guidelines that the facilities have been receiving, since the onset of COVID, plaintiff's counsel is going to have a checklist of here's all of the things that this facility was supposed to be doing. The state told them this, the governor's order said that, the federal regulation said this, and they're going to walk down that line and have an expert testifying to show what you complied with, what you didn't comply with. And then, of course, there's the emotional component. So this goes back to what we're saying about the narrative and the storytelling. When you have the populations, typically in long-term care facilities, it's very easy to make a emotional and compassionate argument. Oh, this was someone's grandmother, this is someone's wife of 50 years, and this terrible thing happened to them. And so throughout the complaints that we're seeing, which again we'll talk about momentarily, plaintiff's counsel is making sure to just dial this sympathy factor, the emotional factor, up to an 11 out of 10. I mean, any way that they can show. And what we're seeing typically to play on this emotional component is two different narratives. The first is that there was a communication breakdown. So something was happening at the facility, whether it was an infection of someone else, the first infection of COVID, or whether it was that individual's family member contracting COVID, there was not proper communication about what was happening, what the facility was doing in response, how the facility was protecting their loved ones, or even in some cases, how the facility then notified the family of the resident's death. And then the second narrative we're seeing is generally the restrictions, which in a lot of places are not even up to the facility. These are state mandated restrictions on visits from the loved ones. But whether you get to make that decision as the facility to allow loved ones to visit the residents or not, it still is sympathetic to the plaintiff that they weren't able to visit their grandmother, their husband, their sister on their deathbed or when they were ill. And so those are some of the themes that we're seeing play out in plaintiffs' attacks in these COVID lawsuits.
And I just wanted to spend a little bit more time on all of these federal and state guidelines and regulations in the context of surveys before we get on to more about the lawsuits. So at the beginning of COVID, you may recall that CMS issued some directives regarding what types of surveys that the individual states would be or should be doing. We had an instance in a case actually where there was a complaint survey. The statement of deficiencies was written up but never issued because CMS basically said, whoa, pull back the reins a little bit. We need to figure out what's going on. Now, there has been some different feedback that we've heard about from CMS in terms of what surveys should be conducted. And there has also been some internal challenges at CMS, shall we say, in terms of how to conduct surveys related to COVID. So as I'm sure you all know, the way that surveys are conducted and many of the regulations that you all are held to aren't really good indicators of COVID related issues. It's kind of square peg and a round hole in some instances. But CMS, at least at the beginning, and I think DSHS has been a little bit more flexible sometimes, but CMS was really aggressive at the beginning in terms of holding nursing homes responsible for some COVID-related issues, but the regulations don't apply well to them necessarily. And so again, as we're talking through the things that you can do to be prepared if you haven't had your annual survey for a while, if you have infection-related complaint surveys, again, documentation is obviously going to be really important, as has always been. The relationship you have with your surveyors is really important because this is pretty new to them too. And again, there's, in my experience, which is much more limited than yours, there's good and objective surveyors, and there's some that are less so. And sometimes, regardless of what you've done and what your records show, there's going to be some preconceived notions about what the surveyors are going to go in and look at. So the more documentation you have related to what you've done in response to COVID and all of the guidance that has come out, the better. But just know that CMS and the surveyors, at least at the beginning of this, were having just as much in the way of challenge and figuring out how to address it as all of you did in your buildings. Obviously, you get the brunt end of that, and the consequences are generally yours, but there are things that you can talk about in terms of what the surveyors see and look at, because they really were not ready for this at all either. So what is the actual litigation going to look like? And I think Madison's going to tell us a little bit about these potential claims.
Yeah, so what we're seeing and what we're anticipating is that the COVID-related claims are going to be broken down here, as we have, into kind of 3 different buckets. The first is what we call typical claims, and those are going to be a patient who tests positive for COVID is claiming negligence in contracting it, or there's a negligence claim for the facility failing to prevent the transmission of COVID. Then we have some more atypical claims, and these really, we don't see as necessarily claims that would stand on their own, but that would be added in addition to the typical claims. So for example, the damages suffered, emotional distress suffered from the loss of being able to have a funeral or attend a burial for that loved one. And privacy claims if, for example, the communications to other family members of residents actually disclosed who the resident was that contracted COVID or who an employee was that contracted COVID, those types of things could be involved. And then, as we'll see in one of our example cases, these civil claims have also resulted in requests for the district attorney to also bring criminal investigation to the facility and to the employees related to the death and transmission of COVID with residents. And then our third bucket is the employee-related claims. And so these would be claims brought by the employees. Again, they could bring a negligence claim if they themselves contracted COVID, and then they could bring safety or health complaints for the facility's failure to comply with safety regulations, OSHA requirements and guidelines that are put in place to protect the employees.
And then, so what happens if, in fact, the patients or employees file claims against the facility for contracting or being exposed to COVID-19? So here again is another slide from the litigation consultants. And as you read these, you know, it essentially responds to a question about what kind of monetary liability should a facility be held to. And baked into these is the assumption that the facility was negligent in some way with their either infection control, complying with state or federal guidance, and that negligence was the cause of either an employee or a resident contracting COVID. So although that is not actually stated in this slide, that is the assumption. And as you can see, by far the component of damages that the general population believes should be paid by a facility are healthcare expenses. Pretty consistent between both an employee and a facility. And we'll talk about kind of what type of claims an employee can legally bring against a employer facility a little bit later this morning. But it's kind of instructive to know that that's, you know, if there's not a lot of healthcare expenses, if there wasn't a serious consequence, depending on the symptoms, depending on what happened, that will obviously drive what kind of damages a jury might award to a resident or an employee. So this is true both of plaintiffs. This is true of surveyors. The surveyors have been, doing this in terms of the, what FTAGs and the regulations that they are using to review your records and talking to your staff. But as we've discussed before, every line of every guidance and regulation is fair game. And there's a lot of them, as you know. I think I heard sometime that aside from the nuclear industry, the nursing home industry is the highest regulated industry in our country. So that has only been exacerbated because of COVID. And so in terms of guidelines about communicating with family or with residents, those are going to be front and center because it's fairly straightforward to find something in one of those regulations that maybe a facility either didn't complete or just didn't write down. And you all know what that means in terms of trying to prove that you have taken those steps. So some of the allegations, as you see, are failing to communicate. That happened more often, obviously, at the beginning. Many of these claims are going to be brought if they're specifically COVID related. You didn't talk to me, all of those types of things. That's going to happen probably for occurrences from the March to June, I would say, probably timeframe, when everything was new. There were no systems in place yet. You didn't have your policies in place quite yet. Things were coming in and guidance was coming in, sometimes multiple times a day. And all of you were scrambling to do your best to comply with those and just do what you knew needed to happen in order to protect your staff and the residents in your facility. But it was challenging. And so things happened in those first few months that wouldn't happen today with more knowledge and understanding of how COVID is transmitted and the kind of lockdowns that have occurred and the restrictions that have occurred. So we expect that those first few months can spawn a lot of claims, some of which we will see in a couple of minutes. So it's, again, we'll say this a couple of different times. The statute of limitations for claims or lawsuits is 3 years. So for things that happened this year, a resident or his family member can file up to 2023. And so that's why it's really important, and even more important, to make sure that you have some things in your file that can help remind you and prove what you did or didn't do in 2020. So Madison shared a little bit about what these claims are. We don't anticipate that these are going to be huge, nor that they'll have a lot of dollar amounts associated with them. What these claims, I didn't get to bury my mom. Bob Smith down the road found out that my mom had COVID because some staff member said to somebody else. These types of claims may not have a high, as I said, damage amount related to it, but what it can do is kind of amp up the emotions of a case. You've seen this with your family members who are quite distraught, reasonably so, if they can't see their loved one, can't participate in a funeral because of the current restrictions. It's very difficult. We all agree with that. But that doesn't mean, again, that anyone on your facility staff should be monetarily liable or even criminally liable. And in one of the examples of the cases that has been filed that Madison will talk about later, she'll address specifically criminal complaints. Sometimes things can get referred to criminal investigation. We've seen that pre-COVID here in the state of Washington against staff members. same basic facts, it's just translated into a criminal context. And that is obviously really scary for everybody involved. Doesn't happen often, but when it happens, it's a really big deal. And the same type of evidence and documentation can be helpful in defending against criminal claims as it does in the civil claims. So in preparation, we're going to spend a lot of time toward the end of our presentation talking about specifics of being prepared for all types of claims that aren't necessarily I contracted COVID or my family member contracted COVID, but anything that occurred during this year while COVID has been raging through our country. So the typical claim, my family member contracted, developed a wound, and you didn't prevent it and you didn't treat it appropriately. That's a pretty standard case we see. When you lay that over COVID, there is now an added element of the plaintiff's case that said, you know what, you already were short-staffed, but you had to then use most of that staff for your infection control. If you had a COVID-specific wing on your facility, you had to deploy more staff to those patients. You were distracted by all of these other things you had to be doing. Your resources were put toward COVID prevention and protection. And so my loved one who didn't have COVID suffered as a result. So we anticipate that even for claims not related to the contraction of COVID, that it will play a role. And so again, the documentation you have about staffing and how you were able to efficiently address some of these issues would be great. We recognize the reality. It takes more time to deal with all of this. You have been stretched thin. Your staff has been stretched thin. That's the reality. That's something that we will face and we will face head on. But it is something just to know that you will probably hear that, and it may or may not be true. And again, that's part of our story, right? People will remember COVID in 2020. And so it's up to us to say, yep, and you know what we did? We rolled up our sleeves, our staff was amazing, and we got it done. And we have some examples of how to do that later on. So I talked about storytelling. And none of this is going to be new to you. Like I said, the best storyteller wins. The plaintiff has some good stories. That side has some good stories to tell, which has been bolstered by all of the press. And the press has not been kind to nursing homes, which has been really unfortunate and very frustrating for those of us who work closely with the long-term care community. So all of you are familiar with what happened at Life Care of Kirkland, and probably have talked to some people who are more involved with this than, let's say, the Washington Post reporter who were writing these stories. But you are going to hear about your infection control FTAG and how many deficiencies you had in the year to two prior to 2020. It's made headlines, and it's made headlines all over the place. As you see from this slide, I don't think these statistics are actually that bad, but 40% have been cited more than once with violations related to infection control. You guys know what that means. Okay, the general public does not. Your average juror may not. And so that's, again, how your documentation of your infection control processes and explaining exactly what those FTAG deficiencies mean, as opposed to, the headlines. But that's something that we're going to hear. So, different stories, different facilities, different employees are going to have different narratives. This was just from last week. And, this was the employees making poor decisions. And there are some consequences as a result. You and I all know that headlines are not usually reflective of the actual facts, but this doesn't help. And this particular nursing home facility is going to have some trouble with defending this case. Again, CNBC, this is from December 2nd. And this story for a plaintiff can be used by nursing homes and the defense folks. It is a perfect storm. You all know that as well. And that is a story that we can tell on your behalf as well, that the way that a facility is set up, right? You have a lot of people all in one place that are vulnerable, have family that come to visit them, potentially have providers that come in or outside third parties, whether it's family. Sometimes you have, home health will come in, and it really did set up a very challenging situation for providers. But the plaintiff side will see that, while this may have been inevitable, the fact of the matter is, nursing homes are on the hook for what happened. So we talked a little bit about specific cases that have already been filed, and we're going to give you a little bit more information about 3 different lawsuits that can give you a little bit better idea of what is out there right now and what we might be able to expect as the next year or two occurs. And Madison's going to give us a little bit more detail on that.
Yeah, so our first example you'll see here is in Oregon, and the lawsuit is actually one of 2 so far that have been filed against the same facility by different family members of residents who contracted COVID and subsequently passed away. So in this case, Jones is the name of the resident who passed away. She is a 75-year-old woman who had cancer and dementia. And her daughter brought this claim on her behalf for the estate and as an heir. And the claims, which I highlight here, are wrongful death, elder abuse, and then there's this general claiming of incompetent response to the pandemic, which I think goes, to a negligence, but they're framing it in a way additional to your standard negligence, and they're seeking 1.8 million in damages from the facility. So the allegations, I think, talking about storytelling are really informative on this case. So a lot of the theory, I think the empathetic or emotional component that we talked about earlier, you can see plaintiff's counsel in the complaint really trying to play on. And in this case, I would say one of the themes had to do with communication. So specifically, there are allegations that they failed to notify any of the family members that there was an infection or COVID outbreak in the facility. So the woman, Miss Jones, was not the first person to contract COVID, and nor was she the first person to pass away from COVID in the facility. But prior to the daughter receiving notification that her mother had tested positive, she had never received a communication from the facility that there was even a single case of COVID, or what they were doing in response to that case. Or when the first resident did die, who was not her mother, there was no communication to the family members of other residents that there had been a death in the facility due to COVID. And so these are all parts of the factual allegations trying to paint this picture of a total breakdown in communication between the facility and the family members. Then when it comes to the daughter herself and her mother's case, she was notified via a voicemail that her mother had contracted COVID and was failing, was doing quite poorly. She was not allowed, of course, to visit or to see her mother even after she was notified that death was imminent via voicemail. And then when her mother did die, I believe 2 days later, she was notified via voicemail that her mother had passed away. And so these types of facts all add up to make a very sympathetic plaintiff. So the emotional component, I think, is being played very strongly here by the plaintiff. Other things which we talked about earlier that we see in this complaint is citations that the facility had received previously in 2019 regarding infection control and regarding understaffing. So they bring those up and imply that that continued to be the case, that they were understaffed and that they did not respond to guidance from the governor and from the state and from federal agencies regarding safety precautions that needed to be put in place in response to COVID. I also think with regard to storytelling, it's very interesting that in this complaint, they really start the story in January of 2020. The woman, Miss Jones, passed away on March 4th, but they start their story talking about how the World Health Organization had declared COVID this big concern starting in January of 2020. And then in February, the CDC here in the US recommended that healthcare professionals are taking certain precautions and they're reviewing their infection prevention and control policies. And then there were CDC recommendations to implement as part of these precautions. And then they cite to the Oregon governor's specific executive orders finding COVID as a threat to public health and safety. And after they laid out all of this months of kind of groundwork, then the story comes around to say, you had all this warning, you had all this guidance, and you as a facility then didn't heed it. You didn't take proper precautions. You didn't adequately respond, even though as early as January, we were all on notice that this was a concern and that your population in your facility are the most likely to contract and subsequently die or have severe health impacts from contracting COVID. And so that is all part of the narrative that plays out then in support of these claims, wrongful death, elder abuse, and then trying to create a valuation of such high damages where you're looking at 7-figure damage claims. In our next, we go to our example number 2. This obviously is the one everyone here is probably most familiar with and has been following to some degree. So this is the Life Care of Kirkland lawsuit. Again, the claims you'll see are very similar. So there's elder abuse, negligence. What I found interesting and unique to this example was that there are also claims of fraud. So fraud in the legal context has to be very specifically pled. There's a higher requirement. You can't just say, oh, they lied to me, that's fraud. There are quite a few specific elements that you have to factually support to make this claim. And so it was very interesting to me that they had thrown these fraud and fraudulent concealment claims in as well. And I guess tangentially or related to that is then the negligent misrepresentation. And when you actually read through the complaint and see the facts that are supporting these claims, it goes back very similarly to our example 1 in Oregon, that they're talking about the communication that was received or wasn't received from the facilities. So they're alleging the negligent misrepresentation and the fraudulent concealment with regard to when there were outbreaks of illness, and that instead the communications that the families were receiving was, we're doing everything we can, everything is going, great, we're protecting your loved ones. And then the reality they're painting on the other side of that statement was, in fact, they weren't following guidelines, they weren't implementing these precautions that they needed to be following, they weren't adequately using their PPE, the staff wasn't properly wearing their PPE, and a whole host of these factual allegations to show they breached the standard of care, and then they lied to us or covered up that they were doing so poorly or not doing the things that they needed to be doing by sending us these kind of rosy communications about what was happening and what they were doing. So again, there's an allegation that there was an outbreak. In this specific case, there was noted in the facility to be what they called a flu outbreak. So at the time in February, late February, the facility believed that it was just a flu in the flu season and that there was influenza. But the allegation is that King County guidance required the facility to notify them if there was any suspected outbreak of the flu, and that after they already had several cases of what they thought was flu, it was 17 days later before they actually notified the responsible health authorities that they had this flu outbreak. And so in that 17-day delay, under the county guidelines and requirements, there was a negligence that allowed the continued transmission, so that I believe in this facility, there were over 129, close to 130 infections, and around 20 deaths. I can look again, but it was quite a few deaths and a very high infection rate, including employees at the facility contracting COVID. And so the allegation is, we received as a family no correspondence that there was even this flu outbreak, let alone when it was confirmed that there was COVID in the facility. There were strong delays in how they communicated to us as family, and then there were long unjustifiable delays in how they communicated that to the respective authorities, and that allowed this to then become, COVID raged through the facility, and they're using strong language like that to paint this narrative about, the parade of horrors, so to speak, for the residents in the facility. Again, we see this is very consistent with the plaintiffs. We talked about that plaintiff plan of attack, and we're seeing as well, I just kind of talked about the emotional component, but again, you'll see on this final bullet point, one thing in this case, they specifically cite to the fact that the facility had failed to hold their consistent quality assurance and performance improvement meetings in 2019. So even leading up to the outbreak of COVID, the facility wasn't following the proper standard of care and following these procedures. And then they outline in detail how the meetings that they did have for quality assurance into 2020 failed to note in the meeting minutes, that's all they have as evidence at this point, they failed to note that this was even a concern. There are meeting minutes from February and into March where we knew that they had this suspected flu outbreak, and none of their quality assurance meeting minutes even note this as a concern that needs to be addressed. And so plaintiff's counsel is then taking that evidence and trying to spin a narrative that it wasn't being taken seriously, the facility wasn't doing what they needed to do to respond to what was otherwise known to the community as being a really big concern, especially for this at-risk population at the nursing home. So then we can go to our third and final example. And this is in Los Angeles, California Superior Court. And again, you see very similar claims. So the claims are negligence, wrongful death, elder abuse, fraudulent concealment, fraudulent misrepresentation. This claim was brought by the family of a deceased man. He's a veteran. They paint him. He had dementia and some physical disabilities, and they paint a very detailed picture of, again, the citations and other problems that the facility had the years prior to the COVID outbreak, including understaffing and kind of corner cutting. I guess if I had to generically summarize all of the evidence they present, it's the picture that they're trying to paint about the facility. And then again, they had these citations, and the argument from the plaintiff is that they didn't appropriately respond then, even after they've been told this is not right, you need to fix this. They still persisted in understaffing, lack of adequate PPE for their staff. And in this case, I kind of previewed earlier, this is the case where civil counsel for the family has formally requested that the district attorney open the criminal investigation into the facility and the staff at the facility with regard to how they handled the COVID outbreak. This, again, I didn't put in the slide, but I can't highlight enough too, which we will get more into as Kristen's going to talk about what facilities do now in anticipation of potential litigation or to protect themselves. And communication with the family, between the family and the facility, is, I would say, exhibit one of all of these plaintiffs' counsel. So the first that they start on these complaints is outlining just a complete failure to notify the family when there's outbreak in the facility, notify the family when their family member contracted COVID. In this last case of Martin, the Martin case in California, Mr. Martin was showing flu signs, symptoms, and the facility did not test him. And the family, at least in the complaint, alleges that it wasn't until they begged the facility to run a test that they got the test run, and then it took so long to get the results back that actually Mr. Martin died before they even received the results saying he tested positive for COVID. And we know on the flip side, again, going back to the N95 mask example that we talked about earlier, we know from the facility side that there also was a delay in rolling out COVID tests. So they were not always readily available. They were difficult to come by, and there were delays in processing the tests. And so while the plaintiff in this case, and again, I don't know particularly that this was the case for this particular facility, but for example, it could be the case that while the plaintiff will argue they wouldn't test him, they didn't get the results turned around in a timely manner, we had to beg them to run the test, and they're trying to paint this very emotional and terrible narrative. The reality might be on the other side for the facility that we couldn't get access to a COVID test, though we wanted to run it because he was showing symptoms. Then when we did, even though we requested expedited processing, they were so backlogged in the testing facilities that it took over 2 weeks for them to get the response back to us that he was in fact positive. Now if that's true, if those are the true facts, that's going to be very helpful to us in telling your narrative in the defense. But what's ideal is that those things have been documented. So when there were requests for COVID tests that were denied or were not made available and without great delay, or the results were backlogged and delayed, having in real time documented that those requests were made and what the responses were to those requests can become invaluable when we're looking at a lawsuit like this. So with that, I'll turn it back to Kristen to go into our next section, I believe, which is about what we do. Oh, let me not get ahead of myself. There's still more claims.
Yeah, thank you, Madison. So the challenges with employee-related claims are in some ways similar and in some ways different than claims by residents. And you all know how hard your employees work and the stresses and risks that have been associated with working in your facilities and all healthcare facilities in general. And as a framework, it's quite similar in terms of how either a lawsuit or regulatory investigation, such as by OSHA, will rely on state and federal guidelines for COVID, for infection. There will be a reliance on that, and there will be a requirement for you to provide evidence that you complied with these. It might be some of them will be similar, most of them will be similar to the evidence that you will need to provide for a resident-related investigation, whether regulatory through a survey process or from a lawsuit. So the general basis for the claims and how we suggest that you prepare for addressing these claims are quite similar, but obviously the laws that apply to how you treat employees is different than how you care for your residents. And a very related issue that I was quite startled by when I saw this slide is the importance in a lawsuit of what perception the outside world, and specifically jurors, will view you based on how you handled your business and treated your employees. So as you can see, when a juror is asked, when they are looking at a corporate defendant, a facility, they ask the jurors, would you award more or less or fewer damages based on how that employer treated their employees and dealt with their business? And as you can see, 59% of those jurors said, yeah, yes, I would. I would either raise or lower the amount of damages I would award to plaintiff based on what I see occurred in terms of how a business treated their employees. So it isn't just the concern of, well, will I get an employee lawsuit based on whether or not they contracted or were exposed to COVID. This drills down right into the bottom line about, again, your story. What did you do to protect your residents, to protect your employees, to support your employees during this really difficult time? And that directly translates to dollars and what that potential judgment looks like. And so again, it ties right into our theme, which is storytelling. What story do you have to tell, and what evidence do you have to support that story that you were working extraordinarily hard to support your employees, that you are amazed by your employees and all that they did? And if that can honestly come through, it can make a big difference in what, at the end of the day, a judgment or even a settlement will look like. Now, there's a lot to employees and how any claims for contracting or being exposed to COVID-19. We actually have several slide presentations on our firm website that we presented earlier this fall. So I'm certainly happy to provide to you kind of employee specific issues surrounding COVID, but it's just important to know that OSHA related complaints skyrocketed. A lot of those were related to healthcare workers for obvious reasons. And so you may have already been involved in an OSHA investigation. Hopefully folks have kind of gotten this down pat in terms of what they need to do, and that may all for you be in the past. Generally speaking, our Employment Security Department has said that a claim for exposure that's just incidental to employment will be denied for workers' comp. Of course, there are slightly different rules that apply to healthcare facilities. And so it's not quite as cut and dried about that. It's a little bit more fact specific. As of late July, there have been about 70 lawsuits around the country for negligence for employees that have either contracted or been exposed to COVID. I don't know that any have been in Washington, and it's going to be pretty hard to win those for plaintiffs. But it's really going to come down to, did you comply with state and federal guidance for protecting your workers? And you are in the unique position that you had to do all of these anyway to protect your residents. So I anticipate that there will be a lot fewer of these cases that are solely about negligently allowing somebody to be exposed. It's just a little bit different category than your standard employer. But as you can see, there are sort of some exceptions to the rule, and those exceptions will be driven by healthcare workers. So we'll have to see how that plays out. I don't think it's as big of a risk as patient cases, especially if you complied with all of the guidance that we've talked about a lot so far today. But it is a risk, and so again, it's something as we're talking about how to try to prepare yourself and things that you can do now. These all apply in the employee context too, and we can talk about those a little bit more as we get closer. But the mantra, follow those guidelines, as you all know, applies for employees as well. So we've talked for more than an hour about all of the potentially scary things that can happen in the legal world, in the regulatory world, which you're all used to, but it's obviously heightened because of what has happened with COVID. So what can you do? We're going to talk a little bit about what that looks like. And I want to say, and we will continue to emphasize this, we understand how busy you are and how much you have to do in a regular world. Certainly with COVID, you are spread thin, your time is valuable, and some of the things that we are going to share with you in terms of in a perfect world may be impossible for you. And we understand that. What we're trying to do is provide to you some ideas that you can implement. You can decide what can work for your building, for your company. We certainly are not trying to, provide an absolute checklist and push you over the edge in terms of your sanity and trying to handle yet one more thing that is on already a full plate. So please keep that in mind as we go over some of the things that we think can be useful in terms of preparing yourself if there is a claim by an employee or a resident or a family member. Madison, you want to talk about some of these first things for us?
Sure. So document. Like we've mentioned before, the best way you can protect yourself is by in real time documenting what you're doing, when you did it, who did it. And so as we've outlined here, when you implemented COVID restrictions, how you implemented the COVID restrictions, the steps taken to screen your employees, to screen the residents for COVID symptoms. Before facilities were completely shut down from visitors, did you have a screening procedure in place to screen for symptoms of visitors to your residents? Document how you handled when that stay-at-home order was handed down by the governor. If there are exceptions, we know there are exceptions for essential workers. When the facility received all of these guidelines and regulations, document how you responded to them. And then of course, it's very important that we have a date of when you did this. So it's not enough, we work with what we get, but in an ideal world, if you, for example, created a new policy in response to the stay-at-home order or guidance from the governor, then we would prefer not just to have that new policy, but also to have the date that the policy was implemented. so that we can then argue, from this day, here's what we did. We received this guidance from the governor on this day, and then within this amount of time, we drafted and implemented and followed this policy to comply with that guidance. So keeping those records and making sure you're including information like the date, the time, when, how you are complying with all of these different restrictions is very helpful.
So in a practical level, I am hopeful that many of you already have your COVID binder or your COVID file that contains COVID-related measures, guidance, new policies, anything related to COVID. So if you have that, great, you can build on that with some of the things that we are talking about today. If you don't have it, or it's not very well organized, or there's not very much in it, then we suggest you start taking steps now to fill that out a little bit. And one of the things in terms of what Madison has talked about is what we believe to be kind of the foundational defense documents that will be useful both if you haven't had surveyors in your building, and we're going to go back and look at that, whether it's a lawsuit. The ground level foundation is what did you receive and when did you receive it in terms of guidelines, new regulations, state orders, governor's orders, CMS, CDC, et cetera, et cetera. And then, as the first bullet point says, then what steps did you take? And you can layer then your response to each of those guidelines. And then we have kind of a map. And then we will keep layering things on top of that to tell our story. So as we've talked about a lot here, you can drive your story. You can write your story in terms of what your facility has done in 2020 in response to the pandemic. And despite what some of the plaintiffs have described in the lawsuits that Madison told you about, there was not in our mind a legal responsibility to track what the World Health Organization was saying about a virus in China. So, but what you are liable for is what you knew once things started happening in your area, and what the different agencies were telling you, and what different nursing home facilities in the state of Washington did or should have done. And when you're writing your story, these are the types of things, as we have discussed before, which really can go a long way in framing an outsider's view of what your facility specifically did in response to the pandemic. First and foremost and front and center, your staff. Your staff have been superheroes, I am guessing, at least certain of your staff. You as managers, as operators, as owners have been heroes in this story. And you need to tell that story. And how do you tell that story? You're not going to remember in a couple of years necessarily that, Nurse Smith or Nurse Jones, went to Walmart to get some masks because you just didn't have enough and you knew you needed them. You aren't going to necessarily remember that the CNA sat and held that resident's hand because the family couldn't get there, and made sure that that resident felt loved and was not alone. Those stories are huge. And while they seem to be, in the forefront of your brain now, they may not be by the time you need them. So write them down, jot them down, about the date, the names of residents, the names of staff, what they did, why they did it. It doesn't have to be a novel. but just jot down what happened and what you recall happened and how people reacted, and put it in your COVID binder or your COVID file or a binder that has COVID stories. This is the real, what we can really use. We can all talk about the policies and the charting and the, you know, did your progress notes, did you put your policy in? But that is not where the stories really come to life. As Madison said, the plaintiffs have a very compelling story to tell. So you need to tell your story in a very compelling way too. Did you not, I'm guessing that there were challenges in getting PPE. Make sure you have documentation, emails trying to get PPE. What did you do when you weren't able to get it through your usual avenues? What lengths did you go to get PPE for your staff in order to protect them and your residents? Write it down, collect those in one place. I'm sure you have emails. I'm sure that you have some of these things, but they may not be all in the same place. It'd be really useful if they could all be in the same place so that if some claim comes through or somebody has a question, you can sort of hand that to the attorney or to your claims folks and say, I can probably get you more than this, but here's a place to start. This is what was going on at the time. What emails do you have about what CMS was telling you? That one day CMS told you this, and then the next day you'd get something from DSHS over here, and then later that afternoon CMS would give you slightly different guidance than they did that morning. Those types of pieces of evidence that are somewhat contemporaneous, so not something that you know, quote unquote, make up later, is really useful in saying, what were we supposed to do? We were doing our best, but we were getting bombarded with sometimes different guidance at different times from different agencies. And so we did, you know, based on our training and experience and knowledge in running a building or treating residents, we implemented what we thought were best practices. And as I said, write it down now. Write down what you remember. That way, it's easier in a year to say, oh, that's right, we did that. So, as we've said before, these lawsuits, it may be 2023, 2024 before you actually present your narrative. And it's hard to remember what happened. People aren't going to remember necessarily their opinions about healthcare workers and what was happening in COVID. Seems crazy right now to think that anybody would forget what we're going through and what you have going through, but we will forget, whether intentionally or not. Many of us would like to put 2020 in the rearview mirror and not think about it again. But the reality is that if there is a claim of some kind in any of these contexts, we're going to need some evidence to be able to help you present your story. So, as we've talked about before, there's the general compliance with all of the guidance and regulations. But the things that you may not be doing right now, and which we really urge you to think about, is staff interviews, family testimonials, resident appreciation for, you know, going above and beyond. You often collect those in various ways, but if there is a way to either keep copies in your COVID binder or somehow facilitate those stories into what you have surrounding your COVID compliance, that's quite useful and can go a long way into creating a really good story. And this is borne out in this survey that we have talked about before. You know, people in the general public are understanding of what you're going through if the story is told well, right? As you can see here, 78% of people agree that most nursing or assisted care facilities are taking all reasonable measures to keep your residents safe. That's a lot. And then there's the no idea. So only 14% of people disagree. So give those people, if any of these people who agree are on your jury, give them the evidence that they need to confirm their opinions, that you guys are doing everything you can. That doesn't mean someone's not going to contract COVID any more than it means that a resident isn't going to fall. It's just helpful to have those narratives available to you. So again, this isn't a perfect world. You may have done some of this, and you can't change what you did in the past. We're 8 to 10 months into this, so obviously getting some of this information is going to be more challenging now than it was a few months ago. But here's some of the things that we've really already talked about. The more detailed you have, the better. Voicemails, text messages, it all goes in there. When you receive something, date it, sign it, who received it, who implemented the policy. And I know that you do this already, but when you're emailing or charting or anything else, it's really useful to be mindful that someone else might be reading those in the heat of the moment. And I'm sure this happened a lot this last summer and spring, is frustration, is stress about what was happening. And that all could be discovered in a lawsuit. So just moving forward from here on out, it's important to be mindful about what you write, which is true for all of us. As Madison said, even quality assurance documents maybe get thrown into a lawsuit, even though there is a quality assurance privilege for QAPI meeting minutes, etc. There's sometimes ways around that. So include those minutes in your COVID binder, training of your staff. I'm sure because you have to do this anyway, for most of the regulations, these are going to be somewhere, but they may not all be in the same place. Your staff training may be in personnel files. It may be in your training documents. That's okay. You can find them, but if it's possible at the same time to make a copy of that sign-in sheet for your CNAs who are getting trained on PPE, put that in your COVID binder under training or your file. It's just going to make it easier to have it all in one place if it's reasonably organized. And again, it's important to date stamp you're receiving any of the multitude of documents you have received in response to the COVID pandemic outbreak. Again, this is kind of along the same lines, but here's the questions that should be asked with all of these documents to the extent you have time to do this. Where are the documents being kept? You have a lot of different places that you might put documents. There might be the QAPI file, personnel files, training files, policies, individual charts. So in a year, when an attorney asks you, okay, what do you have related to your infection control procedures and Mrs. Smith and whether or not anything specific was done for her? How do you answer that question? How many different places do you have to look? Certainly, we do not want to duplicate your efforts in a number of these, but it will be useful to have some of these all in one place, as I've said before. Who created them? You may have someone who, obviously you have someone who does specific training, so you will know who that is. The folks who are implementing the policies, if they're clinical, are obviously the clinical staff. But again, all of this is made easier if you can provide this information and document this information now and jot down even. None of this has to be necessarily in great, beautiful order. Jot a note, put a Post-it note on it as long as the sticky will stay, so that you at least have a trigger in your mind as to what happened at that time. So you already know this as well, but from a legal perspective, this is really, really will be helpful in the context of what Madison was talking about in terms of these actual lawsuits that have been filed so far. And that's this resident-specific documentation, not just the facility-specific, but then the additional precautions that you've taken. And I've seen some charts that, you know, have that, the COVID testing, the care plan updates, you know, the psych assessments now that they can't see, have live visitors visit them. And then those extraordinary measures, again, that you and your staff are taking to assist your residents and their emotional and psychological well-being. How you've set up virtual visits. I know some facilities, you know, have visits through the window, over iPads, whatever that looks like, write it down. I mean, I've heard, you know, about some of these creative ideas that you and your staff have provided that I don't know makes it into a chart necessarily, or not every time. Have you documented? I mean, and how hard is this? I understand for every, you know, iPad visit that a family has with their resident isn't necessarily going to make it into the chart, but, you know, provided an iPad to Betty so that she can FaceTime her daughter whenever she wants. Or the family have provided that, and we check in every day to make sure that she knows where her iPad is and how to FaceTime if she wants to. Jotting that down in the record, at least on occasion by the CNAs or the nursing staff, is really helpful. You have a couple of those in a chart, and suddenly that narrative about not caring, not communicating, not giving the residents or the families what they need, that sort of rings hollow. So to the extent that any of these ideas that you have to try to provide additional services and help to your residents can be crucial.
Kristen, we do have a question around that while we're on that topic. Someone just asked if you could address the benefits of late documentation entries, and is there a best way to do and provide those?
To provide late entries? Yeah,
yes.
They're not ideal, but I would rather have a late entry than no entry at all. And I think that the best way to sort of mitigate the after the fact documentation is to explain why it's late. So, you know, if it is just, you know, I finally got to this today, I mean, that's honestly a lot of why it is to say, okay, I was busy taking care of residents, and so I did do this, but I couldn't document it right at the time. You know, it depends on how late it is, right? Is it a, you know, next shift, or is it the following week? If it looks completely like the only reason that you are doing a late entry is CYA, oh, they fell. Oh, yes, I did have the gate belt on, and kind of a laundry list of things that would appear to try to mitigate that. That's a little bit more problematic. But if it's, oh yeah, I did help her with her iPad, or yeah, the family did come and visit, it didn't get into the system yet because I was, you know, making sure that my residents were, you know, properly fed or whatever. You know, you don't want to oversell, but to the extent you need to late chart, try to late chart on things that are not vital, I guess. Things like social, psychosocial, those kinds of things are better for late charting than meds or things like that. But again, I'd rather have a late entry than no entry at all. And I'd rather have that late entry closer in time to the day or the missed time. You know, a few hours or even a day is better than a week, as I said. But they do have value. The only exception, I guess I would say, is I have had cases where, you know, there seemed to be, the investigation was started. Somebody says, oh, I better make sure that that I charted that, you know, the bed alarm was on. Well, do you know the bed alarm was really on? And why are you saying that, you know, 2 days after the investigation was started when the conclusion has, you know, it looks like you're creating the conclusion after the fact. So that you have to be really careful about, but especially right now, you know, you go back and late chart because you just didn't get to it last shift. It happens. Try not to make a habit of it though, I guess. Does that answer the question? Let me know if you need follow-up on that. I'd be happy to.
We do have one more question around documentation. This is specific to the Life Care of Kirkland incident. What documentation or lack of documentation led to an allegation of consistent or effective coffee meetings? Was it a lack of meeting minutes? Was it a lack of performance improvement plans? Can you give more details on that?
Madison, did the case talk about that at all, or the complaint? Oh, are you muted?
Madison, we can't hear you.
Oh, okay. I don't know how I got muted, but I was muted. Can you hear me now?
Yeah, thanks.
Yeah, so it is just a complaint, which means that the plaintiff doesn't have to outline all of the evidence that they have. But from the complaint itself, with regard to these meetings, they argue generically that in 2019 they did not hold consistent meetings. So one can assume, though they haven't spelled it out here, that there's going to be evidence that they were happening intermittently, if at all, right? Not at the regular intervals that would be best practice. And then they do cite specifically to 3 different meetings that were held. They cite the dates of those in early 2020, from January through February timeframe. And they even have pull out quotes from those meeting minutes that revealed that, for example, in the complaint itself, they cite to a February 19th, 2020 meeting where the minutes revealed, quote, no reports of infection concerns at the facility. But in reality, at least according to the complaint, they already had, at the very least, this suspected influenza outbreak amongst quite a few, I believe maybe 17 residents had flu-like symptoms at that time. And so they are quoting directly to the minutes from those meetings.
And we don't, you know,
the question. Sorry.
Yeah. So that, you know, the way complaints are laid out is it's just whatever the plaintiff wants to say in a complaint that may not at the end of the day be backed up by evidence. And I don't know how the plaintiff would have gotten a hold of copy meeting minutes. It's possible they did a public records request of everything that CMS and RCS had obtained through their investigations. Those are not supposed to be, you know, privileged documents like copy documents are not supposed to be produced through a public records request, but sometimes they are, and there may be some other way that the plaintiff obtained those minutes. So something to be mindful of, certainly. And we'll just see. I'm guessing that this won't go all the way to trial, but we'll keep an eye on whether or not some of these allegations are actually true and that's actually what the minutes say. It's hard to know right now.
All right, we do have one more question, and that is, how can you stop staff from outside activities such as a wedding or a birthday party when there are more people there than the guidelines recommend? Can you require them to stay home for 14 days and not pay them?
So it's always better to request than require, and say, you know, everybody at this point knows that attending a 300-person wedding is not a good idea. That doesn't stop people from having poor judgment or just really wanting to see the family and celebrate these the people that they love have their vows. You can require that if there has been potential exposure, you can tell them that they need to quarantine, or that if you have a reasonable suspicion that they have been exposed, to require, certain testing. A lot of the employment requirements around like the ADA and some of the healthcare associated information and restrictions have been overridden by the risk factors. And so the EEOC has issued some guidance that supersedes some of the prior responsibilities that employers have to kind of not ask about healthcare and things like that. So I certainly can follow up about specifics, but generally speaking, yes, if you believe that they are a risk, you can require quarantine, etc. I know that staffing is an issue anyway. Hopefully, depending on where you are and what your testing looks like, if you can get tests, at certain periods of time, say, if you have 2 negative tests within 3 days or whatever, depending on the test, what you think is appropriate, you can either have them quarantine or do some testing in order to ensure that they are not positive after an event like that. But you reach out to me with specifics if that is a concern, and we can provide you some specific guidance from the employment perspective. Certainly that's there's certainly looser guidelines on that to try to protect employees, employers, and in your case, residents. Thank you for all these questions. We just have a few more things, and they sort of are the same mantra. We've talked about this a lot. It may just be you spend a few minutes a day, you have a staff person gather them, spend an hour on a Friday to try to gather some of this documentation if it already isn't in one place. And so we've talked about all of these things, and realistically, what can you do? So from our perspective, if you can only do 3 things, or even one thing, in sort of order of importance, here's what we would recommend that you do, is to have your binder, and put as much in it in an organized fashion as you can. And then I really, really would recommend talking to employees about how they can celebrate their fellow employees. It's sometimes hard to get employees to talk about themselves, but it's usually pretty effective to say, hey, I would like you to tell me in a couple sentences the one person that you have seen that has really done an amazing job during COVID. Tell me what they've done. Tell me how they've helped a resident, how they've helped you. And I think that they want something positive. They want to celebrate. You may have already done something like this. Collect those. Collect those, have them date it, put it again in that file or that binder. It makes people feel good. And that, of course, helps regardless. But it also will provide a really good narrative for what was happening and has been happening in your building, despite all of the challenges and stress and fear. You guys have some amazing employees. I've seen them. I've talked to some of them. They're extraordinarily upbeat. They love their residents. They just want to take care of them. So have that come through in writing now, so that when it comes down to, some sort of claim where, there's chaos in the building, everybody's grumpy, everybody's scared, nobody knows what's going on, you say, really? Because here's what my employees had to say about it. That's really powerful. And so that's something that may not take a tremendous amount of time, that can go a long way to helping you write your story. And then I know that you all are doing this anyway. Take good care of those folks and document what you did, little things that you did, as I've said before, to just help make them feel better. You're doing it anyway, so document that you're doing it. And you all have been extraordinarily creative and caring and helpful. So if there's a way that you can describe that, or have families describe that, if a resident says that, write it down. Those are the things that should hopefully make you feel good about the job that you're doing and remind you why you're doing this job in the first place, but also help you down the road to kind of really setting a good foundation for the defense of any type of claim that might be coming down the pipeline. So Diane, are there any other questions that anybody has for us?
There are not.
Okay.
You guys have another minute here to get your questions in. There was someone that was asking if there will be a recording available, and the answer to that is yes.
I also have, if anybody wants to reach out to me directly, here's our contact number, or you can go through Diane or Jennifer. If any of you want to see that entire slide deck from those consultants of the surveys that everybody took, please feel free to reach out. It's kind of interesting just to see kind of what people have been thinking about the long-term care community, generally speaking, and kind of lawsuits. I was pretty fascinated by it, and I live in this world all the time. So please feel free to reach out for that. Or if you have any, as I said, employment-related questions, we're happy to provide some resources in that way also. So my slide, for whatever reason, disappeared. Oh, there it is. Again, this is our contact information. We're happy to answer any questions that you have if you have them after this. And again, we really appreciate the opportunity to talk to you today and to try to help you along as you are meeting these challenges head on. And once again, I want to thank you for your service and all that you do for these residents and their families and the rest of us. You really are heroes in our eyes. Over the last 20 years have been just amazed by how much you do and how much you care. So once again, thank you very much.
All right, thank you, Kristen and Madison. We would like to thank everyone for joining us today. Thank you, ladies, for sharing your time and sharing your knowledge. Special thank to our sponsor, Ryan Swanson in Cleveland, for bringing us this important webinar. This was very well attended and lots of good questions, everybody. Please watch your emails for instructions on how to obtain your CEU certificates and the recording of this webinar. Thanks, everyone. I'm going to end the event now and stop recording. Everybody have a good rest of your week.